You've probably been there, right? A deadline or a bill is due on a Saturday, and you wonder, do I have until Monday? Well, a recent Supreme Court case hinged on that exact question. And for one man, the answer would change everything about his life in America.
See, at the very center of this whole thing is a man named Hugo Monsalvo Velazquez. He'd been given 60 days to voluntarily leave the U.S., the country he'd called home for 2 decades. The big problem? Day 60 landed on a Saturday. And that one single detail kicked off a legal fight that went all the way to the highest court in the land. Now, this is not just some abstract legal puzzle we're talking about. At its core, this is the story of a father, a husband, a business owner whose entire future was literally hanging on a ticking clock. So let's talk about who Hugo Monsalvo Velazquez is. He wasn't a recent arrival. He had built an entire life over 20 years in Colorado. He was married, had 2 American kids, owned a home, and ran his own business. He'd been granted something called voluntary departure, which is basically a chance to leave on your own terms rather than being forcibly removed. All of that, his entire life, was on the line.
Okay, the timeline here is absolutely crucial. On October 12th, that 60-day clock started ticking. Day 60 fell on Saturday, December 11th. The government said, that's it, that's your deadline. But Monsalvo's lawyer filed a motion to reopen his case on Monday, December 13th. So the whole case boiled down to this one simple question. Was he on time or was he 2 days too late?
And believe me, the stakes here could not have been higher. If the deadline was Saturday, his motion was late. Period. He would face forcible removal and a devastating 10-year ban from most types of immigration relief. But if the deadline was Monday, his motion was on time. He could keep fighting his case and dodge those massive penalties. The difference a single weekend could make was just enormous.
But hang on, before the Supreme Court could even get into the weeds of what days means, they hit a huge procedural wall thrown up by the government. The question became, did the courts even have the authority, the jurisdiction, to listen to this argument in the first place?
So yeah, the first fight wasn't about the calendar at all. It was about the courthouse doors themselves. Were they even open to someone like Monsalvo? I mean, he wasn't challenging the order to remove him, just the math on a deadline within that order.
So the government's argument was pretty strict. They basically said, look, to get a court's attention, you have to challenge the fact that you are removable. And since Monsalvo was only questioning the deadline calculation, they argued the court couldn't touch it. But the Supreme Court saw it differently. They pointed out that the law lets them review any question of law that comes up from a removal order, and this whole deadline thing was a textbook question of law.
Justice Gorsuch, writing for the majority, really put a fine point on it. He said the government's way of thinking would force people to make up bogus, flimsy arguments against their own removal just to get a court to hear a totally legitimate legal question. The court pretty much said, yeah, that makes absolutely no sense.
Okay, so with the courthouse doors officially kicked open, we can finally get to the main event. When the law says 60 days, does it mean every single day on the calendar, weekends included? Or does it follow that common sense rule most of us know, where weekend deadlines just roll over to the next business day?
To answer this, the court turned to this really important legal idea. It's called longstanding administrative construction. I know, it's a mouthful, but the concept is actually pretty simple. It's the idea that when Congress writes a new law, it's not doing it in a vacuum. It knows about the existing rules and practices of government agencies, and the assumption is that the new law is supposed to fit right in with those traditions.
So here's how the court basically connected the dots. First, you have the history. For decades, since the 1950s, the government's own immigration rules have said that weekend deadlines move to Monday. Second, Congress passed this 60-day law knowing that this was the standard way of doing things. And third, and this is a huge point, other deadlines in the exact same part of the law already follow this next business day rule. So the court's conclusion was pretty logical. Why on earth would Congress use the word days to mean 2 completely different things in the same paragraph of a law?
So after all that, what was the final verdict? Well, it's interesting. The justices all agreed on the first question, but they were a bit split on the second one.
First, in a unanimous decision, the court said, yes, federal courts absolutely have the power to hear these kinds of deadline questions. You don't have to cook up a fake challenge to your removal just to get a judge to listen to a real problem. This was a huge win for just being able to access the courts. And second, in a majority decision, the court sided with Monsalvo. They ruled that when a voluntary departure deadline lands on a weekend or holiday, it automatically pushes to the next business day. It was a victory for common sense, really, backed up by decades of practice.
So you might be thinking, okay, a deadline got moved from a Saturday to a Monday.
Why does this case about a technicality actually matter so much? Well, let's break down the real impact here because it's bigger than you might think.
The ripple effects from this are pretty significant. For one, it gives immigrants and their lawyers a clear, common-sense rule they can rely on. It also sends a message about how to read laws. The context and history matter. It opens up access to the courts by getting rid of a pointless hurdle. And at the end of the day, it's a win for the idea that the law shouldn't be a gotcha game that depends on the luck of the calendar.
And this whole case really leaves us with a fundamental question that's way bigger than just immigration law. When a law is quiet on a detail, what do? Do we look to decades of common practice and tradition to fill in the blanks? Or should we be strict textualists and say if it isn't spelled out word for word in the text, it just doesn't exist? It's a core debate about how we should understand and apply the law itself.